right, good morning, Phyllis.
Good morning.
I see everybody's still standing.
Is it okay for me to keep this here?
Sure.
Okay. I won't do it in the jury's.
Yeah, but it's fine today. It's fine. All right, so we just gotta, do we have any significant motions today, or just?
Judge, I think we've got some motions that we are going to be able to stipulate. Our first motion, if the court recalls, that we filed and we talked about briefly, was the fact that it is not relevant, and in fact, not only is it not relevant, but it violates 403. Any evidence, any mention, any photos dealing with the signs at the theater having a no-gun sign. And the government has agreed to our motion. And so we would ask the court to rule on that initially.
Okay, so that was your motion in limine?
It is.
Okay, so I'll grant the defense's motion in limine regarding the sign. It is I'm irrelevant, so you have an order for that?
We do, Your Honor. We have some judicial notices that we filed with the court. I believe the government is in agreement with those judicial notices, and we would ask the court to rule on those as well.
Okay, I remember seeing those. I don't remember what it was, but it wasn't a shall, it was a may.
Until now, and it becomes a shall.
Right, of
Yeah.
course. So, I got no problem,
Yeah.
but I was just trying to think of what was it?
They were committee notes.
Oh, that's it.
So that's
Thank
that two-part rule of evidence where with notice, then the court shall.
Okay, so it is a shall one, that one? Yeah, I guess it would be.
Well, it becomes a shall after we give notice.
After
like
you give
Mr. Martin
notice.
did
Okay.
As well.
Okay, gotcha. All right. So those will be, I will take judicial notice of.
Your Honor, I think Mr. Martin has a couple of them.
Judge, the first one is, well, hang on just a second. Judge, I filed a motion to use transcripts as aid. I had to refile it based on the court's previous rulings because we talked about the redacted,
Oh, right,
and you said everything is coming in.
yeah,
Okay, so I refiled it with everything coming in.
okay,
I have provided it approximately, I don't know, maybe 10 days ago to
Okay.
defense for them to review and determine if they have any objections to the accuracy of the transcripts between the audio and the transcript.
Okay.
I haven't heard anything from them. It is the same transcript that was played previously in front of Your Honor. So that's where we are. I have the motion's been filed. I attached the transcripts, both the first and second interview to the motion, and also provided the court with the jury instruction that parrots the jury instruction in this situation, which includes when there is extraneous conversation that takes place, even and which is covered in the jury instruction.
Okay.
So, based on the court's ruling, I'm asking that you grant that. The law enforcement interview, Mr. Reeves, will be played in the state case, that the transcripts be provided to the juror. Of course, they will be collected afterwards. And I have the jury instruction proposed, so I'm asking the court to accept that jury instruction.
okay. Is that a standard instruction?
It is. You have to look at a couple different places, but
Okay.
just put it all together. It not only deals with telling them how to listen and how they use it if their memory is different, but it also includes where, like I said, there's extraneous information, and explains that you're not to consider those opinions that don't relate to anything. So
Okay, very
I
good.
was trying to alleviate that, but Your Honor said everything's coming in,
Yeah.
so that's the jury
So
instruction.
there it is, okay,
That
we'll
they
deal
get.
with it.
Your Honor, I told Mr. Martin that I would not have any objections as long as it was the actual transcript that we played in the standard ground hearing. We are going over that again, but as you can imagine, you have to listen and go word by word. We haven't gotten to that yet, but I trust his word, and if it's the same one that, you know, that was introduced before, I'm sure we're not gonna have a problem, but we'll have that answer to him by Sunday, because we're having some of my folks that are going word by
Okay.
word on the transcript.
All right, I'm sure the state wouldn't go out and get a
No.
new transcript,
No.
you know,
No,
but,
it's exactly.
And that's why I'm saying I think
Yeah.
it's gonna be a no-brainer.
okay, very good.
So where are we at with it? I mean, we're at the eve of trial, and we're trying to prepare too, and I appreciate that everyone's busy, but at least in this particular case, it was given, so
All right, let me ask you this, Mr. Martin. Is that the same transcript that was used previously? I guess it would be the same one that was used in the Stand Your Ground, correct?
Yeah.
You haven't, there's been no new transcripts, no alterations, no, the only difference was you had redacted it originally?
no,
Oh, you hadn't yet?
no, the original one was full.
Okay,
Because there
the
was some
original
error.
one was full, I mean, just this time,
And then I went back, I did my redaction.
okay,
And then I had the transcript that I submitted.
Uh-huh.
You said no.
Okay.
So I've gone back to, I just pulled back up the original
Okay.
transcript, attached my motion. The only thing is different is now the jury.
the
we have
jury
to have a
instruction. Okay, very good,
I take
all
your
right.
word for it.
Okay, then, it'll be, that's how, what we're gonna go with.
So may I submit an order saying that's
Yes.
granted?
Yes.
Judge, the second motion that I have, that I filed, is a motion to designate David Bryant as a witness identified with an adverse party under 90.612.
Granted, you can argue if you want, but granted. It worked, you know, as Mr. Martin pointed out, it works both ways, that's fine, granted. I mean, you know, we've sure had a lot of adverse witness designations in this case, probably more than I've ever seen in my whole career, because usually folks don't call adverse witnesses, but it's okay, that's fine, granted. I'll rule the same way I did for the defense, so.
I'll submit an order, proposed order to council this afternoon for their approval, then we'll provide it to you
Okay.
hopefully by the end of the day
Okay,
on both of those.
that's fine,
I'll do it as soon as we leave court.
all right.
Judge, the other matters, we had some previous stipulations, I'm sorry, I was sitting.
Oh,
We have
that's all
some
right.
previous stipulations that were filed, and both the state and the defense will be relying on. One of them is a stipulated order concerning facts pertaining to DNA evidence. That was stipulated to back in February of 2017. The state will be relying on that stipulation, and I believe the defense will as well, but nothing has changed, and of course, that stipulation carried over to any other future trials. So that one is in the court file.
Okay.
It was filed February 17th. The other stipulation that is still in effect is a stipulated order regarding facts pertaining to Chad Oulson's use of his cell phone on January 13th between 1 and 1:30 p.m. Again, both parties will be relying on that stipulation. It was signed February of 2017. Again, it was stipulated it would remain in effect for future proceedings, including this trial, and it was filed with the clerk on February 17th, 2017. So that one is still in effect. The next one is a stipulated order concerning waiver of authenticity and chain of custody objections to specifically identified evidence. The court might recall there was numerous hard drives or flash drives regarding the video from Cobb Theater. It also includes the Rose radiology of the MRIs and X-rays of Curtis Reeves. It also included, because the defense used the hard drives that were in fact turned over by Cobb Theater, that their cloning of our evidence is part of the stipulation, which is set forth on page 2. That one, both the state and the defense will still be relying on. And again, it was filed, this one was filed or dated January of 2017 and was filed in open court on January 30th. Again, we agreed that it will remain in effect throughout the proceedings, including this trial. The other stipulation that is still in effect that was agreed to in February of 2017 is a stipulated order concerning waiver of best evidence rule requirements to specifically identify evidence. Cobb Grove Theater camera surveillance system data from January 13, 2014. Both parties, again, will be relying on that stipulation during the course of the trial. Again, the stipulation carried forward to any future proceedings, so the state's position is that stipulation is still in effect. There's also a stipulated order that we signed back in February of 2017 concerning waiver of authenticity objections to specified identified evidence, photographs. It sets forth on page 2 and 3 all of the photographs that the state and defense will be relying on during this particular trial, just as in the previous hearing. Both parties will be able to use the photographs. There will be at least no objection as far as authenticity, as far as whether or not the photographs fairly and accurately represent what was captured at the time that the photograph was taken. So that is, and again, that carried over to future trials. So the state's position that that particular stipulation is still in effect. One of the...
If you want me to comment on the stipulations.
No, you didn't do that yet.
Judge, we agree with all those stipulations. I have one issue with one of the stipulations that I'd like to discuss with the court. One of the stipulations obviously deals with the phone that was imaged, Mr. Oulson's phone that was imaged, that clearly showed that he was not texting his daughter, that just an opposite, he was surfing on the internet, and I believe he was surfing some football sites and some racing sites and that sort of stuff. We intend to actually show that stipulation to the jury at opening statements, because it's been the topic of conversation out there by the media, saying, oh, Chad was texting his daughter, and oh, Chad was, poor guy, he was texting his daughter, when in fact he was lying. He wasn't texting his daughter at all. So it's a powerful thing for us, and we want to be able to, and we want to let the court know and have these arguments now before we get to opening statements, that the court's not going to have any problems with that, because it's a focal point of this case that we've got to dispel very quickly.
Stay.
Who took that from you? Or just a moment, Your Honor. I haven't had a situation where there was an attempt to impeach a deceased previous words. I'm just trying to think that through as far as the relevancy, and is it really relevant what he says? So what, it wasn't true. He had a gentleman that was pestering him, and he was telling him whatever it would take for that man to leave him alone, so who cares? So I get it, but I'm trying to think, I'm trying to think through how we get an inconsistent, how to prove an inconsistent statement of a deceased as he's, yeah, one of the things, I mean, we're here on a case involving a claim of self-defense. That's what's relevant. And like I mentioned to the court, you have a situation where you have Mr. Reeves constantly having contact with Mr. Oulson, unwanted contact, clearly from his response. I won't say the words, but and so you have a statement that is hearsay, but it's not offered for the truth when it was made to Mr. Reeves, because it was simply saying something. He could have said, I have a blue boat and leave me alone. I mean, it doesn't matter what he said. It was the effect upon the hearer of, I'm doing something, leave me alone. So I don't know if you can impeach that or show it's inconsistent. It's just it's an irrelevant collateral issue. And so I don't agree with that.
All right. First of all, I agree that the facts are what they are. I mean, you've got the evidence that what he was doing, and I agree with the state that that's kind of a convoluted area. However, it's without question that that statement did appear to elicit some additional sympathy for the deceased. Whether that's matters or not, I mean, that's kind of where I'm struggling, other than obviously if it elicits sympathy for the deceased, that may impact the accused. So, Mr. Escobar, yeah, go ahead.
Then he can respond. My concern is calling Chad Oulson a liar, and that's what they want to do. And if you want, this is coming in, and okay, and he made those statements, but to have the character assassination of calling the deceased a liar is not appropriate, because it wasn't offered for the truth. It was simply a way to get this man to leave me alone. So to call him a liar, I think is just totally inappropriate.
Response?
So, yes, he stuck with it because he agreed with it, and it is relevant in this particular case. And let me tell you why it's relevant in this particular case. There is absolutely no doubt that in the stand your ground hearing, if you recall, they actually introduced witnesses that said that Chad Oulson said, oh, I'm texting my daughter, okay? And so if that is not prejudicial to my client, when we all know, everybody in this courtroom knows that that is not true, because forensically, their experts, forensically, my experts, have determined that that is not true. And so somehow, we want to keep it can't be kept out of the jury because it's coming in, it's stipulated, okay? And so what are we saying? That we can give it to the jury in the form of a paper, but let's not talk about it. It's evidence. And I am allowed to talk about all of the evidence in this case because we are speaking the truth here. We don't want to keep anything from this juror. Let's just think if this panel goes back and violates the court's order and listens to the TV, and someone says, hey, about that, it's been all over for the last 2 weeks. Poor Chad Oulson, he was texting his daughter. And one of these jurors hears that. And now we have no way to argue that to that jury, that that's not true. This is a court of law. We're supposed to introduce everything to this jury that is true. We've got a gentleman's life in my hands, and we're worried about Chad Oulson, who literally lied in that theater? Is that what we're worried about? Your Honor, I think it's very relevant. I think that what was in Chad Oulson's state of mind at that point in time is relevant, and certainly he wasn't texting his daughter.
Okay, so let's simplify this just a hair. I certainly understand why the state would stipulate to that, because it is in fact proven that he was not texting his daughter. And obviously, you know, a stipulation would curtail hours or days of back and forth with experts about was it, did it, and if, you know, so, and that's not, as officers of the court, none of us are supposed to put forth an idea that we know not to be sustainable. So I get that. Secondly, though, I don't think it's fair to characterize Mr. Oulson as a liar also. I don't think based on that one thing that you can just come out and say he's a liar.
Well, I'm sorry, Your Honor. I'm not going to say, we're not going to say in opening, Chad Oulson's a liar. What we're going to say in opening is that Chad Oulson was not texting his daughter.
Okay. I think that's fair.
Yeah, I wouldn't do that. I mean, that's...
Yeah, that you know.
I've said it here because I want the court to know that obviously he
Okay,
was
I
lying.
got you, but, yeah, there's really no way around it. In fact, you know, apparently that was not true what he said, obviously. So, I think that's fair game because it's like I said earlier, it's without question. We have heard it over there in the individual voir dire about what they've heard. I heard it at least once. I want to say more than that, maybe 2 or 3 times that someone said, I heard, you know, he was texting his daughter. So obviously that little point has resonated with folks, and I'm assuming that the state doesn't intend to elicit that, or, well, maybe you will, that from any of your witnesses that he said he was texting his daughter?
Well, that's what the witnesses heard.
Okay.
So, I mean,
Okay.
they heard it.
Okay, okay.
And it was, the fact that it was said is true. So the witnesses who are
Okay.
going to testify that's truthful testimony.
Correct.
Because they're truthfully reporting what
They
Mr. Oulson
heard,
said.
sure.
Correct.
Okay.
So yes, we are going to.
Okay, so, and certainly, obviously, the jurors are instructed not to allow sympathy to sway or influence their verdict, but I think it's fair game for the defense and relevant to introduce the fact that he was not texting his daughter. No liar characterizations, but obviously, you know, untruth, not true. That's fine. All right.
May I continue, Your Honor?
Yes.
Anything else, Mr. Escobar, before I
No,
continue?
none of the stipulations, sir.
There was a stipulation that was filed and then signed to back in 2017 regarding the stipulation to the identification of Chad Oulson. In reviewing that, preparing for the trial, I noticed that there was an error, which I'm correcting.
Okay.
I submitted this to Mr. Escobar, I guess, months ago now. So I don't know his position right now, but we did it before, so I'm asking him to comment on whether or not his client is going to sign the stip. I still don't have it.
I had told Mr. Martin that we're going to sign the stip, and we signed it last time. It's, you
Okay.
know, it's a pretty benign stip.
Okay. I want to go back to the texting information. The defense is not going any further than to say exactly what he was texting at that time, correct?
Oh, yeah, no, I mean, I think the stipulation actually embodies what he was doing.
Okay, all right,
Would you like to look at it, Your Honor?
sure.
I'm going to hand it to your bail,
Okay,
or your
thanks.
deputy.
I know what you're thinking of. Can we approach?
Sure. This is off the record. Okay, very good, that'll do. And what was it, Tina, you wanna hand this back to me?
Yeah.
What was the correction on the other one? Something minuscule?
Yeah. The title of the, when it's accepted by the court, I didn't have the correct title.
Oh, okay,
Thank you.
all right.
We all do that.
Yes, indeed. See it
So
all the
anyway,
time.
I'm just correcting it.
Okay.
I have the stipulation, I have signed it, and I'm handing it to Mr. Escobar in open court.
Okay, he's
And
signing it.
ask that he sign it and have his client sign it, and maybe that's something it'll take you.
When-
Yeah.
When we bring it, when Monday?
Yes.
Just hand it back to me, and we'll have him sign
All
it.
right, then it'll be real quick.
Okay, very good.
All right.
That's an easy one.
The other stipulation is the second stipulated order concerning facts pertaining to ballistic firearm evidence. We have a situation where there was a stipulation previously regarding distance from muzzle to target. And Jennifer Clark was the FDLE agent who did the firearms examination. And in her report, it was she reported out and she testified in her deposition that, in her opinion, the muzzle to target distance was a range of 0 to 36 inches. All right, so, and we relied on that original stipulation previously. In this particular case, it's incumbent upon the state to prove that the weapon used in this case was in fact a firearm. It meets the definition of a firearm pursuant to the statute under 790. So I have amended the original to include that finding by her, because in her report, the deposition, she did test fire it, and it is a firearm because it is a device that is designed to fire a projectile by explosion. It's a whole thing, so it does meet the definition.
Okay.
So I've had some discussions with Mr. Escobar, and I believe as we stand here today, it's still that we agreed that we don't need to bring in Jennifer Clark just to say 0 to 36, and this is a firearm.
Okay.
So that's what this stipulation is
Okay,
about.
I think I saw
previously-
that one. Did you file that?
Yes, ma'am, I
Okay,
found them
yeah, I
all.
saw
So I have a blank one here. Today is the 11th.
And Judge, just so you know, my position is, if that was, again, the original one that we had signed, but only with the added information about the firearm, we're gonna sign it right now. I trust him. We haven't gone into minute detail to see
Well,
word for
look
word.
at it.
No, I mean, I trust you. You're not gonna. Okay. This has got to be signed by Curtis as well, so,
Yeah.
on Monday.
Yes. There's a new stipulation that Mr. Escobar and I have been discussing for the last couple of days. It's regarding some videos that was produced by the examination of the FBI expert. I provided the two videos to Mr. Escobar. I believe we are still in discussion regarding that, to have his expert look at what I provided him. But that would be stipulated order regarding State's Exhibit number 3. That is still in the works, and hopefully by end of today, if his expert can look at the video, well, or Saturday, there'll be either a yay or a nay from the defense, and we'll continue to work it. But that would be one thing that would be pending at the court. If it's resolved, then it would be simply the court, we both agree, the defendant has agreed and asked the court to accept. So that will be held in abeyance until Monday morning.
Judge, this is the thumb drive that I got from Mr. Martin yesterday. And so I do intend to take it to Mr. Koenig so that he can review it. It's my understanding in speaking to Mr. Martin that it does not involve any interpolation or resizing. I'm sure you remember the arguments that we had before Judge Lewis. He has indicated to me that it only has to do with a brightening or lighting of the actual film.
Okay.
So I'll get that checked out by my expert. Assuming that everything's okay, then we'll talk about it and see.
Okay.
I will tell the court that I noticed in that particular thumb drive some unusual lighting effects, and so that's why I need to go to Mr. Koenig and see what
Is
took
this from
place.
Mr. Imel?
Yes, it was produced back in 2016.
Okay.
And that's when the discovery was. So it's been in our possession for a long, long time. It's just, we're trying to, we'll work it out, but that's what's going on with that.
And real quick on that note, just so I got an idea, a general idea of how this is gonna go with the two, we just have Mr. Imel and Mr. Koenig for video expert. Was there somebody else?
Yes.
There was early, but they took him off the list. It was
Well, it's not off the list. He's just, I need to see where these steps go, so I can't, I'm not gonna say he's
Judge,
off the list.
let's talk about them, because he is off the list, because if you recall, we wanted to take his depo for the second time. You indicated no.
For what?
This is Mr. Weiland from Orlando. Is that who you're talking about?
No, I don't know who that, oh, no.
He's off.
He's off.
Himmel.
Oh, no, Emil's fine, but Mr.
No,
Weiland, okay.
I don't know how you.
There was another expert out of Orlando that didn't do a very good job, and so that's why I went to Mr. Emil. And so we stopped the depositions of Mr. Weiland in Orlando because he was having palpitations during depositions and all kinds of stuff. I think he had a heart attack or
Yeah,
something.
that name hasn't come up
Okay,
before.
and so the other name that you're saying?
Emil.
Emil.
I-M-E-L.
Oh, okay,
He
but I've
testified.
been saying Imel.
It's, yeah, okay.
It's Emil?
Right, but that's not even close to Wyland, so I don't know where
Okay,
Mr.
okay, all right, so.
No, Mr. Immel is not off the list.
Okay, right, I gathered that,
Oh,
and I'm
okay.
sure Mr. Escobar did too. So I know often when there's these types of video experts and enhancing, if you will, typically are you gonna play the original raw video first and then enhanced, or how's that gonna work?
Well, we're in the process of working out. That is the discussion that's going on between Mr. Escobar and I. It is my intention to play the raw video before any testimony in this trial. It was exported from the devices obtained from Cobb Theater by Mr. Immel using the proprietary software. It was using the EXE file. It was exported in an AVI format, which is what the GeoVision software does. And the software is set up so that because it's motion activated, the software knows where that is, and the software itself places blue screen where there's no video.
Okay.
But the timestamp keeps running. That's all done by the GeoVision software, not Mr. Immel, other than just hitting the button to run the export. Because you can export it as recorded video only, which would be no blue screens. It's just back to back, and it's misleading to do it that way.
Right, that's where the missing frames
Well, yeah,
talk
because
came from.
yeah, because there's no
Right.
recording. So you do it in real time, and that's when the computer software places the
Okay.
blue screens in, and then the timestamp runs continuous.
Gotcha.
So that, and it's unenhanced, unresized, it's just out as an AVI. I have both the AVI format, then it was converted to another format, MOV, so it can be played with QuickTime as opposed to another type of player. The advantage of QuickTime is you're able to use the cursor keys
Okay.
very, very easily to go back and forth, and you don't have to drag a thing. So, but converting it from AVI to MOV is just the can, if you will, that the video comes in. It's just so it can be played in a different player. It doesn't change. So it's still the same content, it's just a different. So that is what we'll be using predominantly throughout the trial. Then the next one is simply it's not resized, it's simply brightened, if you will. And that's what we'll be looking at. So to answer your question, yes, the raw video will be played up on a large screen, and there you go. And then here, go ahead.
I hate to throw a wrench into this, but this is a couple things. So I think we're in agreement then that he will not be playing, nor will I, any videos that do not have the blank spaces, whether, I think his are blue, mine are black. Because if you recall, part of this process at one point in time was that the last video image was kept through that period that there was no recording, and then the recording started. So it gave you the perception that that person sitting there for 30 seconds was the image of the person sitting there for 30 seconds, and it wasn't. It was that image happened 30 seconds ago. And so now I think, he's put blue screens.
I didn't put blue
Well, we
screens.
did. We put black screens to make sure that that perception by the jury was not going to be realized. So that, I think we're in agreement with. The next thing is really important. As a court knows, these motions concerning interpolation or resizing, we filed many, many, many years ago. I think back as far as maybe 2016. The process that creates danger here is the unknown. And let me tell you how that works. He has told you, we're showing the raw video. Well, that would be true if you were showing the raw video in the correct size of the video itself. But the minute that you now start through your machine, through your big screen, to want to show it in a 75-inch screen, what happens now is that screen has to do something with that very small picture. Because remember, the video quality of this camera and system was very, very poor. And so you're taking something with not so many pixels, and now you're having to add a tremendous amount of pixels in order to get it into a 75-inch screen. And so the question then becomes, how is this screen doing that? And so he's got, I think, a 76-inch screen. I've got a 75-inch screen that I'm bringing in here. If you remember the arguments that we had before Judge Lewis concerning their experts attempt to resize. They were using something called bicubic smoother, where no one knew the algorithm that was used by that software in order to resize the image. My expert was using nearest neighbor, which we do know, okay, without question. Nearest neighbor is you're taking the actual pixels that are nearest to that particular pixel that you're trying to enlarge, and you're just duplicating it. It's a mathematical formula. It's been tried and tested for years. That's what we do for our expert. However, now, not only do we not have this bicubic smoother issue, now we have an issue with a particular brand of screen that's going to interpolate this particular image into a 76-inch screen. And so all those other pixels are being done by the computer and their algorithm, which we don't know and he doesn't know, and frankly, his expert doesn't know. And so what does that do? What that does now is it's introducing to a piece of evidence additional information that's not there to begin with. Now, we're doing it a different way, and it's costing us a bundle to be able to do it because we want to show it on a 75-inch screen as well. And my expert will come and testify to this. We're doing it via nearest neighbor, and the way that my experts are doing it is we gave them all the specs of our screen. We said, here are the specs. He said, okay, then we're going to do nearest neighbor to those specs so that the machine is not going to do anything. My experts are doing it by nearest neighbor to the size of that machine, which is forensically what should be done, because we shouldn't be introducing anything to a jury of an unknown. I mean, think of how dangerous that is, because we don't know if the machine is using bicubic smoother or some other algorithm that they've come up with in order to resize that film. So I'm presenting this to the court. You know, the same problem happened in the Rittenhouse case. I don't know if the court is aware of that. The prosecution in the Rittenhouse case was using an iPad, and they were trying to zoom in on a particular area. And the defense said, wait a minute, you can't be zooming in on that particular area because now you're enlarging the area's pixels, and you don't know what algorithm is being used in order to do that. So you are altering the evidence. You're actually altering the evidence because you don't know what the algorithm is. If you knew what the algorithm is and you could forensically come in here and say, oh, no, it's not being altered in any way, then everybody's comfortable. So I believe, and if I'm not mistaken, I don't believe that they were allowed to do that in the Rittenhouse case, but whether they were or not, it's not of importance to us. I just want the court to understand the situation that we're going to have here and the fact that there's a way of doing this when you're not allowing an algorithm that you have know nothing about to manipulate your evidence, and that's what's happening.
Judge, the state's going to rely on Judge Lewis's order in this case where she addressed that issue. And I'm relying on that. We will be playing it on the whiteboard. According to Judge Lewis' order, that will be admissible. We're not here to relitigate that. If he wants to place that information from the jury, I'll handle it appropriately. But to answer the court's question, we will be playing the raw data
On a big screen TV.
on a big screen TV, and that is consistent with Judge Lewis's order. So yes, the raw will be played.
Okay.
Now, as the court, I believe, was pointing out, that the procedure normally is you put in the raw data, your expert comes in, explains the process of enhancements. Enhancements can include brightening, contrast, removing color, but enhancements does not involve resizing. Resizing is a different, and that involves the interpolation that we've been discussing, the difference between nearest neighbor and bicubic. And so I'm not using anything that in which the software which Mr. Immel used to produce his product involved resizing or any type of interpolation. It's kept at that, that was not used. What the only, quote, enhancement was, it was brightened, was increased, and that's what they're going to look at. So potentially, I want to have that available to use during the course of the trial, along with the raw data. That's what Mr. Escobar and I are working on, and that particular video will be played on my screen, consistent with Judge Lewis's order.
Okay.
Judge, we certainly, respect Judge Lewis's order. I don't want the court to think that we don't. But this is an issue that is an important issue, and we would have to object to his presentation unless he does it via nearest neighbor, which is the forensic problem way of doing it.
As Mr. Escobar pointed out, I think the 10 days has run since a rehearing on Judge Lewis's order. So if he wanted to relitigate that, he needed to file a written order. A written motion within 10 days, so res judicata applies, and there is no more argument
All
on
right,
that.
so certainly for record purposes, you can object contemporaneously and we can talk about it. But as I read the order, both are allowed to testify, which seems perfectly rational. It's just a little battle of the experts, and I don't remember the differences. I did not obviously see the videos during the hearings with Judge Lewis, but back when I did, the reason I want to make sure, at least for argument's sake, some version of the original or raw is shown to the video, because we do have this battle of the experts, and the jury needs to be able to make their own decision, and as I said, it's been a long time since I've seen the videos in any shape, form, or fashion, but
Judge, we can introduce the mirrored hard drives. I think we would stipulate to that.
You can't, sure, you can put in the mirror hard drive, but it's a hard drive and nobody can play them. So that's useless.
That's the evidence of the mirrored hard drive.
right.
But it's what's extracted from that is you have to be playable.
Right, and that's, and I agree that, as I recall, the way the theater would look at it was on a screen about this big probably. So it is what it is. I think in the grand scheme of things, it's not, there's no question, it's not the best quality, no matter how it comes out. And as long as the jury can see the original, then they can decide for themselves which expert they want to listen to or believe or give weight to, however you want to put it. That's my only concern, that they have a basis for their decision or giving weight to either or both experts. So, and again, in the grand scheme of things, I don't know, like I said, I don't remember the if there's big differences in the videos. So, I don't know. But the jury, as long as the jury can make their own, come to their own conclusions, that's all I'm worried about. So,
We'll continue our discussions, hopefully before we leave the courthouse today, so that we can resolve this issue.
well, what do we need to resolve?
Well, one of the things that has been in discussion is the playing of the original, I'll call it the raw original,
Yeah.
whatever, first original, at the very beginning, with some sort of introduction. This is the video from whatever, and we indicate that that particular video, both parties agree that it basically it is what it is. It captured the movement and interaction of Mr. Oulson and Mr. Reeves on that date. We're working on the language, hopefully
Okay.
before we leave the courthouse today, we can resolve that issue, and then it can be played, because we're all gonna be relying on it.
Right.
And so, and I want to go ahead and play it originally, and Mr. Escobar and I have worked together in the past before. I'm sure we can work it out in a very short period of time so that we can,
Okay.
we'll have that for Your Honor, then we can play that, and then the rest of, we can.
So you would,
The only issue, just so that you know, and I think we can work out language as long as we don't include that I am agreeing that it fairly and accurately depicts what happened, because it's the resizing on the big screen. I mean, I can't, as a lawyer,
do we need to even have that language in there?
yeah, if we don't have that language, you're good.
Because, I mean, that's definitely arguable by all accounts, I would think, because it's big, where, you know, I mean, that in and of itself is different. So,
I think they had, I don't know what it is now, but when we had the hearing, I think, Dean, am I right, was it 4 million pixels were added? I mean, it's crazy.
All right. Let's try to get back to planet Earth, okay? The issue here is in my hand. I have what fairly and accurately was captured by the recording device. There's no question about that. The issue is when I plug it into any electronic device, it'll be different on your computer, it'll be different on that screen, it'll be different on that screen. At some point, every examiner does what they do on their computer. They make it look visually what they feel it is, but they will admit that once it leaves and leaves their computer, and once you plug it into anything, yes, our electronic devices everywhere, that Elmo is going to change a picture.
Right.
So we're just, and so here's my example. It's like taking a postage stamp, saying, okay, here it is. You know how small it is? And you're taking a magnifying glass, and you're putting it over, so you can see it. That's what I meant. So to argue, okay, this doesn't fairly and accurately, that's why it just kind of makes your head hurt. I can't say that this fairly and accurately what I have in my hand, but as soon as I put it on a big screen, it's junk. See what I'm saying? It just doesn't,
I do.
it makes my head hurt.
Okay, let's put it into context. That's a very good context. We do that in every single trial, just about. I can't remember too many criminal trials that we haven't put something on the Elmo, stamp, a shell casing, and all of a sudden it's up there and it looks this big. And it's still a fair and accurate depiction. We all know it's not really this big, but we don't have all this argument about it. So, what about that? I mean, why can't we just skip all this?
Because a lot of the changes to that particular photo, you're not going to be able to see with the human eye necessarily because
Then who cares?
Well,
What difference does it make? If nobody can see it, what?
you can see it, you just can't see the differences with the human eye. And so, you know,
So they
this
must
is,
be minuscule.
Judge, this is forensically, listen, but, you know, my guy was the head of the FBI lab for I can't tell you how many years, so, you know, I am relying on what he is saying, and he's saying, Rick, forensically, okay, this is not appropriate, because you're allowing a machine to alter that piece of evidence. Now, I told him, if he wants me to stipulate, like we've stipulated already, that, you know, the original, you know, hard drive that was actually seized from the theater, and these particular products came from that, I'm willing to, I'll say that's the authentic, you know, hard drive. We had our experts determine whether that was the authentic hard drive. But when he brings 3 thumb drives and he wants me to say, okay, well now what's in these 3 thumb drives, when I put it in that screen and it gets to be 75 inches, that I believe that it fairly and accurately depicts, I can't do that.
Okay, so here's where I'm having a little difficulty, and where I'm starting to think that this whole thing may have, you know, maybe this is being really blown out of proportion. Because my concept of altering a video would be, say, if the state's video or your video suddenly shows Mr. Oulson doing the shooting. That would be different. But if the changes are a tiny fleck of light on Mr. Reeves' ear, that, you know, you might not catch on the other one. I mean, good glory, really? Does that constitute not, suddenly it's not fair and accurate, or?
But Judge, he can introduce it. I'm not saying that he's not going to, Judge Lewis's order allows him to introduce it, okay? So it's not like he can't introduce it. He just wants me to say that it's a fair and accurate depiction, which I don't have any obligation to do.
Okay, all right. So I'm thinking that maybe there won't be a stipulation to that, but I guess I can rule.
He just doesn't, you know, he can get it in by his expert. If IMO takes the stand and says, this is a fair and accurate, you know, then it's in.
Well, he's gonna say it's fair and accurate when it was on his computer. He can't comment on the whiteboard.
He wants me to comment.
Okay.
So here's the thing. If the court wants to decide, the court can decide. If the court doesn't want to decide, I'll have further discussions with Mr. Escobar. Like I said, I'm trying to get back on planet Earth. I mean, good grief. I don't know how many times I've played stuff in a trial. And I'm using the same tried and true predicate that we've used for my entire career. So now I can't play anything, anytime, unless the state and everyone else goes to the expense and buys a monitor, that we know what the resolution is, and we change everything to fit that monitor. I'm sorry, we get to the point of being ridiculous when it doesn't make any difference.
Judge, just let me make one point. He says, his expert, his FBI expert, can't get on the stand and say, okay, well, I took this from here to here, and it fairly and accurately depicts what I took from here. He can't do that, but he wants me to do it.
Okay.
Do you see the problem forensically for me to be able to do that when my expert's saying, look, Rick, it's an unknown, and we do things forensically, and we do it precisely, and we do it accurately. And unless that equation is here, you shouldn't be stipulating to it. He's going to get it in. I don't have a problem with him getting it in because of Judge Lewis's order. It is what it is.
All right, well, just, his statement is just not accurate. The extracts from the hard drive are the hash, and he's already indicated that from what was previously stipulated, all those to the ones that I gave him, that is true. His whole argument, which he left out when he just spoke, is not what's on the hard drive, it's what's on the monitor. And so what he just said was contrary to what he's been saying. He goes, okay, you put on your expert to say, okay, what you extracted came to here. All right, if that's all that has to do, that's what I'm trying to work out with him, is with my discussions, he didn't have a problem with that. The whole problem was me plugging it into a device. Now he's changed, so I don't know where we're at.
All right, this is how I kind of, an example I think is kind of analogous to this. I'm reading a Florida Supreme Court opinion here. That's binding on all of us on my computer, but my eyes are very tired from working all week, so I make it bigger. Does that somehow mean all of a sudden that's not, I'm relying on something not valid? I mean, that's kind of the impression I'm getting here. Just because we're using it on different, we all know how computers work, I think, and obviously you're going to explain it to the jury that there's some changes made, and I hope that's where we're at, that I'm not sure who's going to explain it. Obviously, you're expert and you're expert in different terms, and again, the jury can take that along with their common sense and make their own determinations. But what's the argument about, I mean, Mr. Escobar, you're saying that no one can say that it's a fair and accurate depiction, and
I think his guy can say that it's a fair and accurate depiction from one source to the other source. What he wants me to do, though, is for the last source, for me to say, okay, I viewed it, and I stipulate that it fairly and accurately depicts what was on the original source, and my expert's saying that I shouldn't be doing that. And let me, we thought of different ways of how we were going to do this to the jury in the most forensically proper way. And, you know, we probably could have gotten 6 iPads or 10 iPads, okay? And we could have put it on an iPad and make sure that the resolution matched the original resolution of the original video, and they could have seen it, you know, that way. Or, like we're doing now, we're going to put it, you know, on a 75-inch screen, and we are resizing it with nearest neighbor, which means that we are using those same pixels from the original to enlarge it. And so, you know, when you're looking at your screen there, you don't know if it's using nearest neighbor, whether it's using bicubic smoother. None of us do, because the manufacturer of your screen doesn't want to release that information to the common folks. And so, you know, I think this is, I think, to be honest with you, I don't know why putting Emil up to say, you know, I got this from this source, and I put it on this source, and it fairly and accurately depicts what was on this source, and we're done. I mean, it's as simple as that, and he gets it up there, and I don't have to compromise, you know, what my experts are telling me is not appropriate.
All right, I guess I'm just a little hung up on the concern that the jury's somehow going to be duped into thinking that this is a fair and accurate depiction. I don't think any of them, I didn't get the impression that any of them are really concerned about algorithms of the computers they use, and most of us don't know anything about algorithms or concern ourselves. It's tools that we use. And as was pointed out earlier, we've done this for, you know, as long as there's been technology. And maybe there was this huge debate way back when we first started using Elmos, for instance. Oh, that's not a fair and accurate depiction anymore. You put a shell casing on and it's only this big, and now up there it's this big, and the jury's going to be confused thinking that it's actually this big. I don't recall ever having things like that. We just did it. And as long, like I said, as long as it's not, you know, suddenly the whole image is transposed or upside down, or, you know, big heads or giant faces, who knows? But as long as it's...
Judge, Mr. Koenig, he's not a doctor, Mr. Koenig testified before Judge Lewis about an incident where, in fact, in the lab, they discovered that that interpolation had made it appear that someone had a weapon in their hand when they didn't. You know, normally, when it's something that is not as important as this video, I wouldn't be jumping up and down, and I understand that we use the Elmo to put a picture up or what have you, but when this video is as important as it is in this particular case, I don't want to make a mistake by agreeing to something that my experts forensically have told me are not appropriate.
All right. I get that. I from the more practical standpoint, I know you both have experts that have told you what they say. So, all right. So back to the ultimate question. Mr. Martin.
Yes, Your Honor.
How is it that you're going to play the video for the first time, the raw video, as we'll call it? Can you guys come up with the introduction?
I think I'm going to work really hard with Glenn to try to figure out the language.
And you know what? I mean, for argument's sake, do you have to say this is a fair and accurate?
What I was working on is indicating under authenticity, authentication, is there sufficient evidence that the document, the photo, is what it purports to be? So, having looked at that, I've drafted something to say that on that particular date that words to the effect that the recording device did in fact capture interaction between Chad Oulson and Mr. Reeves inside Theater 10 and at various other locations within the theater on such and such a date between such and such time. And that really tracks Earhart and some of the case law is it what it purports to be. It purports to be the interaction between these two individuals at various times, various locations within the theater. So I haven't discussed that with Mr. Escobar. That's what I've been working on, and he and I will talk about it. So to answer your question, does it have to be in there? No, but I don't think there's any question. I don't care what kind of interpolation or whatever you do, you're going to see something to the effect of something being tossed, someone being shot. And that ain't going to change, I don't care who expert. So I think that language is vanilla enough, if you will, that it meets the authenticity requirement without saying that word. I'm just tracking what that means. So I will discuss that with
All
Mr.
right.
Escobar.
I think
Maybe
you
we can
guys
come to an agreement.
Work it out, yeah.
I think we can.
All
We'll
right,
work something
fair enough. Okay. Anything else?
Hopefully, we can work on that before we leave today and maybe have something quickly to you by the end of the day on all those matters.
Judge,
And I'll
there
get
is-
the orders.
There is the issue of the information that we talked about yesterday.
Correct.
With what I would consider to be superfluous and prejudicial additional language
Oh,
in
that's right.
in the information, only on, obviously, the murder count. And I would ask the court that, I guess one or two things can happen. Either if the information is not going to go back, which you've indicated that it's not, then do we need to make sure that there's no instructions whatsoever that give the, I'm sorry, Judge, I should be saying that, there's no instruction that gives the jury the impression that you can commit a second-degree murder by causing great bodily harm.
Well,
Well, first of all, they're not.
well, not in this case, but can that occur? Yes, you can create great bodily harm, then 10 days, a year later, the person dies from
Okay.
that great bodily harm. So
Okay.
yes, it can occur.
Okay, so, but that, I don't think we need to waste
Yeah.
much time on it, because the information is not going back, nor is it even gonna be ready. And so the issue's gonna be with the jury instruction, and I don't think that's really an issue. In this case, there's no question that it was a death. There,
And I believe that's what Mr. Rosenwasser has submitted to the defense.
I spoke to Scott, but he's not here. Is he around?
No.
Judge, I spoke to Mr. Rosenwalder today, and so,
I'm sorry, excuse me, Mr. Escobar. He was upstairs, so I'm gonna text him. He wanted to come down for this part, Judge.
Okay.
So if you can just
Okay.
give us a moment, please.
Sure.
That'd be good.
sure.
sorry.
Do we have
No,
anything
I-
else we can discuss in the meantime? Anything else? Or are we almost wrapping it up?
Judge, I think that there was going to be some discussion concerning, I've read, and Mr. Michaels is actually going to handle this, is the testimony of both Dr. Hayden and Dr. Roy Bedard, and what is the court going to allow in the presentation of both of these witnesses. I have read Judge Lewis's order, and I can tell the court, I'll let Mr. Michaels, it's his motion, and so I don't want to step on.
Okay, go ahead.
Excuse me, Your Honor.
Wait.
My discussions, and maybe I misunderstood, even with the court and with the defense, that this is what we were going to handle this morning. So I am not prepared to argue
Okay,
those.
you had indicated that yesterday, and I'm not forcing anybody. We don't, this is a big issue,
It is, Judge. Well,
and we're all tired. And,
it may or may not be. You know, I've looked at the order now probably a gazillion times, and if you read them together, probably have no questions, but We'll address it when, at the appropriate time.
Yeah,
That's We have time.
I've indicated previously that there, you know, in accordance with some other case law cited by the second DCA, it seems like, and I might as well just put it out there, like I think I already did, the final wording, it's really improper upon my reading of the case law. The case law cited in the Draca opinion, a recent opinion by the second DCA, they also cited other cases where it's improper for an expert to opine as to one of the final elements, you know, an element of the, whatever it's talking.
I don't think that Mr. Bedard is intending to opine as to the reasonableness. He's not going to put himself in place of the jury.
Well, and that,
He's
he
just there
even
to fill
said
in.
that in his,
Right. He wouldn't do it if you asked him.
exactly, he said, I read his testimony from the hearing and listened to it, and he said, I think that's more jury question, when, you know, when I think, it was you,
During the
questioning
hearing.
him, yeah,
That's
during the
right.
direct. And you said, have you come to an opinion as to whether or not Mr. Reeves was reasonable in his actions, something along that line? And Mr. Bedard, Dr. Bedard said, I think that's probably something that the jury's supposed to decide, but yes, I do have an opinion. And you said, what is that opinion? And he said, I think it was reasonable.
Right.
Judge, I think you might have them just a little bit confused. Dr. Hayden at the previous hearing did testify that he believed it was reasonable for Mr. Reeves to believe that he was in imminent danger. Dr. Bedard, in his depo that I took with Mr. Michaels there, Mr. Bedard did not testify previously. It was Dr. Hayden. So that's why
I listened and read the transcript of the hearing.
Right.
that was
Bedard-
Dr. Hayden.
Well, Dr. Hayden was at the
No.
immunity hearing.
Right.
Bedard was at the hearing.
I can pull it up.
The hearing
The
of motion
page.
limiting.
Yeah, that was at the Dalbert
The
hearing.
Dalbert.
Right.
Right.
Right, that's
Okay.
what I'm talking
No.
about.
Oh, I'm sorry, I thought you were talking about the immunity. I apologize.
So,
But Hayden definitely did say that, and I can see why the state may be concerned, because in the order for Dr. Hayden, the court ruled that as such, Dr. Hayden may give his expert opinion about justifiable use of force. So I don't know if, I can see why that may be problematic to them. I can tell the court, it's not our intention to have our expert get up there and act as a juror and say, I'm an expert, and in my expert opinion, he was justifiable in use of force, or he was reasonable. It's not gonna be that. He's gonna give
Okay.
background cues. There's something-
okay, and that was my concern when I read the order, and there wasn't any really limiting language as to that aspect, and the case law is pretty clear that's not proper. And of course it wouldn't be. You can't have an expert come in and say, yeah, I'm an expert, and I think, that was,
It'll be my 7th juror.
right. And I could hear the jury back there, well, he's an expert, clearly he's got all this training, so he says he's reasonable,
I'm an expert, and in my opinion, it wasn't justified, and he should be not guilty. He's not gonna say that.
Right.
Well,
Okay.
but it's it's the reasonableness. Was this reasonable? Was that reasonable? That's where there's a problem.
Okay, and that's where we're gonna have to take some more time. To what extent, and I did, I read the Draca opinion of the second, and I even looked at the trial transcript of that to see what the second was considering and what was actually said and what they felt was proper and not. And Dr. Bedard's, is he a doctor too?
He's a
PhD.
Yes. His testimony did get, it sounded like was making Judge Ballone a little nervous. And I think there was even a curative at some point. So yes, we definitely need to talk about parameters. and how much he can testify.
Like I said, I'm gonna pull it out, all the issues, because it's more than just that, but I was trying to get everything done so we could start Monday, so I
Yeah.
apologize for
Yeah,
that.
I didn't really anticipate that you would have much done this morning on that, so I'm
And I'll
not
discuss
concerned.
it more with Mr. Michaels,
Okay.
maybe we can
Yeah,
come to some agreements like we need to do on some other
It's
issues.
fine, and Your Honor, it wasn't for lack of effort. We had telephonic communications up until midnight, I think, maybe an email after that, so it wasn't because of a lack of effort by any means.
no, there's been no lack of effort in this case, from start to finish, I have to say that. That's one thing I can say unequivocally. So, and this week has been no exception, so.
I see that Mr. Rosenwasser is here, and so we can hopefully make this short and sweet. I think we both agree to this, and Scott, if I say something that you don't agree, just...
We're talking about first the information that with the great bodily harm, and I indicated that that's not, the information never goes back, first of all, and won't go back in this case, and secondly, I've read the information for the one and only time that I will in the beginning of voir dire, and I won't read it again. So the information will not be considered anymore by the jury, so it doesn't matter what's in the information. But the jury instruction is what we need to talk about.
Judge, I'd like to talk about that in two parts, and we're going to do, I would like to do, first of all, I'd like to kind of give you my impression of what this jury instruction entails and what the law entails in reference to justifiable use of deadly force. And I know the court has read probably as many, if not more, cases than I have read. But we've been dealing with this for a lot of years. And I want to term this, and I want the court to see what you think about this term. There's an objective standard that this jury is going to have to apply to evaluate a subjective assessment by Mr. Reeves. They're going to have to apply an objective standard, standing in Mr. Reeves' shoes, in order to determine and evaluate a subjective assessment by Mr. Reeves. The subjective assessment by Mr. Reeves is that whether he reasonably believed that he was in imminent danger of death or great bodily harm. So the first part is, was Mr. Reeves in fear of imminent danger of great bodily harm or death? Now, we know that the danger doesn't have to be real. And so what do we do with that? And I'm actually going to cite some of the cases just because, I think we agree. Mr. Rosenwasser sent me some cases that we had. But I'm going to use those, and I'm going to talk to the court about what the court is saying there. So I'd like to read, first of all, the 776.012. There are two statutes here that we have to deal with. 776.012, which is called the use of force in defense of person. And then the next one's kind of tricky. In the Mobley case, I'm sure you've read the Mobley case, really clarifies somewhat the confusion that many courts have had with this statute. But the second statute is 776.013, which initially in the first two sections deal with someone invading someone's home, residence, or vehicle. And so if you just look at the title of 776.013, you would think, oh wait, this doesn't apply, it applies to a house. However, they go down to subparagraph 3, and it applies to everyone. And so let me read to you, first of all, 776.012, use of force in defense of a person. And these are the important parts, not the entire. The important part of that statute says, however, a person is justified in the use of deadly force and does not have a duty to retreat if A, he or she reasonably believes. So right then and there, the statute's telling you, wait a minute, he or she has to reasonably believe that such force is necessary to prevent imminent death or great bodily harm to himself or herself or another person, or to prevent the imminent commission of a forcible felony. And then it has an or. Under those circumstances permitted pursuant to 776.013. So this is where 776.012 directs you to 776.013 subparagraph 3. So that's how we know that these two statutes have to work in conjunction with each other on justifiable use of force. And so now we go to 776.013, and we know that 1 and 2 doesn't apply whatsoever because that is strictly language concerning invasions of your dwelling, residence, or vehicle. But number 3, this is what it says. A person who is not engaged in an unlawful activity, and I think we all can agree here that Mr. Reeves was not engaged in unlawful activity, so we can put that in the basket, who is attacked in any other place where he or she has the right to be. And so we can put that in the basket as well because he had absolute right to be in that theater. Has no duty to retreat and has the right to stand his or her ground and to meet force with force, including deadly force, if he or she reasonably believes, again, emphasizing the fact that Mr. Reeves reasonably believing, that it was necessary to do so to prevent death or great bodily harm to himself or herself or another, or to prevent the commission of a forcible felony. And so my next issue is, how does a jury do that? How does, a lot of the cases that you read, it's a stand your ground hearing. And so they're saying, how does a court do that? Well, now we've got a jury. How does a jury determine if that subjective assessment of Mr. Reeves, that he reasonably believed that he was in imminent danger of death or great bodily harm, how do we, the jury, determine that subjective assessment to be reasonable? So how is that jury going to determine that what Mr. Reeves's belief, that he felt it was reasonable that he was in that fear? How do we determine that? That's where you go now to the objective standard. And so I'm going to cite for the court Vieira, which is located at 163 Southern 3rd, 602. Matt, you have that for the court so that we can pass it forward?
Mr. Esparro, what statute are you referring to? 013?
I'm referring to 013 and 012.
I know, but what section of 013?
3.
Glenn, it's the 2013 version that we're going under.
Yeah, you're in the new book.
Okay.
I have
Yeah,
my
I
own
was
book
too. I
up.
was like, I'm
Yeah.
not reading that.
Yeah, you've got to go back to the 2005 statute that applies in this particular case. We've got it. We can. I can also give it to the court.
Do you want a copy of Vieira?
Yes, please.
Your Honor, there's some underlining in it. I showed it to Mr. Rosenwasser. He's okay with it.
Judge, may I approach? I'm going to also give you the law that applies to this case.
Yes, thanks. And we're going back to 2005. Why?
Because that is the statute that was in effect at the time of this particular.
That's the version. I'm just looking at the 2013 Florida statute. So
Yeah, that
this
was,
should
the
be-
2013 actually became effective, I think, in June or July.
That's,
Yeah, 2013.
2014 did,
yeah,
yes.
so 2013.
Yeah. Should we wait for
Yes,
Mr. Martin?
yes, please. Okay, yeah, because I was looking at the 2021, and I'm like, it
That's a
doesn't,
different.
it doesn't reference 013. Where is that? Okay, better now, thank you.
I think when we first started this case, we had to read the Mobley case like 5 times. It's a very confusing process that the legislature used. These are the cases, Vieira and Toledo, that were supplied by Mr. Rosenwasser to us last night, which we had, and we agree with.
Judge, I have a copy of Toledo I can pass for.
Okay, thanks.
Again, there's some highlighting in it. It looks like my highlighting matches Mr. Rosenwasser's
Okay.
highlighting. When you look at it.
Imagine that.
Really, we all agree it's the law.
Imagine that. See, that's how we roll. Thank you.
I think ultimately, what Mr. Escobar is saying, I'm going to say is, because I'm imagining you're going to transition now into the objective standard.
Yeah.
And we're all going to agree that's what the law is.
Okay.
I just think it's good before opening statements that we all get this out in the air and we all realize what we're going to say in opening statements and not have arguments in the middle of that. To the Vieira case, Your Honor, which is located at 163 Southern 3rd, 602. You've got that, I believe, in your hand.
I do.
I'm going to read certain excerpts of this particular case because I think that they're right on point with what the law is. And it says the objective standard is to be applied by a trial court. Remember, Vieira is a stand your ground immunity hearing. The objective standard is to be applied by the trial court in evaluating the factual circumstances presented, and then it goes on. And it says the standard requires the court to determine whether, based upon the circumstances as they appear to the defendant, because it's evaluating Mr. Reeves's subjective assessment of the situation. And so, as it appeared to the defendant when he or she acted. And so what are the circumstances? And I think Mr. Rosenwasser agrees. The circumstances are that you have Mr. Reeves, who is a 71-year-old. Dr. Cohen is going to testify about what happens as we age at 71 plus. We're going to have Dr. Foley talk about his health condition, his bones, his brittle condition at the time. The fact that he was a retired police officer with extensive training in the use of force, that's another circumstance that the jury has to consider. That it was in a darkened theater, that the movie previews were loud, that he was in a close confinement, and on and on and on. So all those circumstances that caused Mr. Reeves to reasonably fear are going to be determined or assessed by the objective standard of that juror standing in the shoes of Mr. Reeves. In other words, it's not Rick Escobar outside of the shoes of Mr. Reeves that can make that determination. It's Rick Escobar or a juror standing in the shoes of Mr. Reeves as he was that day that is making that assessment as to whether or not his fear was reasonable. And now you go, obviously, to Toledo, which is a case, again, that was provided to us by Mr. Rosenwasser. And in the area of reasonable and prudent person. A reasonable and prudent person situated in the same circumstances and knowing what the defendant knew would have used the same force as the defendant did. In other words, even Toledo is saying, now wait a minute, you can't take this in isolation. You've got to take all those facts that Mr. Reeves possessed in making that determination as to whether his belief was reasonable. And then in Toledo, finding that a person in the exercise of his right of self-defense may use only such force as a reasonable person situated as he was and knowing what he knew would have used under like circumstances. So,
Excuse me, Mr. Escobar. We don't disagree with any of that.
I was just thinking,
So
wait a
why-
minute, what are we arguing about
I
again?
have no idea.
it's coming. So now we're going to apply the actual use of force instruction. And we may not be in disagreement. I haven't shown Mr. Rosenwasser, the jury instruction, but I think that, we certainly ought
Well,
to.
we do, we read it during jury selection.
Are we proposing a non-standard jury instruction?
No, but we've got to
Okay.
take out certain portions of the jury instruction.
That would be a non-standard, unless it's discretionary according to the evidence.
Okay, well, I'll tell you the sections, okay, and it's 3.6F, justifiable use of deadly force. The one section that, in my opinion, and you've got that as well, the one section that has to be taken out is in the, I think, 4th or 5th paragraph, where it starts off by saying, however, the use of deadly force is not justifiable if you find that Curtis Reeves initially provoked the use of force against himself. So there is no provoking here by Curtis Reeves, and therefore,
No, that's not one that's usually discretionary, I don't think. I'll look at it, just got the,
Judge, I think that a lot of these cases dealing with use of force certainly suggest to the court that this use of force should be tailored to the facts and circumstances, because you don't want the jury to think that Mr. Reeves saying, Mr. Oulson, can you turn your phone away, is provocation, because that is not legal provocation by any stretch of the imagination.
Judge, the problem with that, you're going to have the testimony, and the inference is, when he came back, as you recall, the phone was put away. People were watching the movie, and Mr. Reeves initiated contact with Mr. Oulson and rekindled the festering animosity between the two. He became the aggressor when he did that. And so having that out there, whether we think it's discretionary or not, is clearly an inference that the jury has a right to consider. That once he came back and everything was over with, the phone was put away, everybody was being quiet, he came back and rekindled that animosity between the two. And so that's something that the jury has a right to consider, and that jury instruction is something they have a right to consider whether or not it fits. So no, that doesn't come out.
Judge, the issue of provocation is not foreign to our criminal laws, and no, language is generally not considered provocation at all in any of our statutes. And so he is absolutely incorrect, and we'll certainly pull some cases for the court in that regard, but conversations, a request, even saying, let's assume that he's correct, which is not. Let's assume that he's correct, and the jury believes that Mr. Reeves, when he came back, he says, oh, I see that you put your phone away, in response to Mr. Oulson saying, oh, you turned me in. That is not provocation by any stretch of the imagination. It is merely a conversation and nothing more. And the danger here, the real danger here, is that if you allow the jury to believe that even a conversation can be what's called legal provocation, there's a body of case law talking about legal provocation. And obviously a conversation is not legal provocation by any stretch of the imagination, but we'll bring the court some case law concerning that particular issue in the near future. And so that's one section, obviously, that I think needs to be taken out. The other section is...
If I can just address something
Sure.
on that point.
Sure.
And I agree, that's probably something that we both need to research. I just find it interesting that this was the instruction that was given to the court to read during defense counsel's jury instruction phase. So they included 3 paragraphs that essentially the defense is now saying shouldn't be read.
And the jury's already aware of it now.
So I just found that kind of unusual.
okay, in the most current version of 3.6F, there's a case cited and it refers to some statutes, so I don't care. I'm not going to make any factual findings, but the usual course of business for jury instructions is you go through each, if there's use if applicable, you have to follow the rules of construction of the jury instruction. So first of all, I'm not changing any standard instruction without grave concern. So secondly, if it is one of those give, if applicable type situations, which it appears it is, then typically, if there's any evidence to support it and either side requests it, then it's given. If there's no evidence to support it, and someone requests it, I usually don't. If there's no evidence to support it, then it's not given. So, and that's my humble interpretation of what we're supposed to do in those cases.
And Judge, I think we both agree we'll get some case law to the court on that particular issue of what constitute provocation, because that's an important issue.
It is.
And so the other thing that I would like going further down, it's next to the last paragraph. It says, if Curtis Reeves was not engaged in unlawful activity. There's no question Curtis Reeves was not engaged in unlawful activity, so that has to be taken out, and it should read, if Curtis Reeves was attacked in any place where he had the right to be. Because the minute that we start putting in language that there is absolutely no evidence of, and the parties agree that there was no unlawful activity taking place, we are putting in front of this jury something that some juror may think that something that happened in that theater somehow is unlawful, and none of them are lawyers.
Are you talking, you're talking about the second last paragraph from the bottom?
Yeah.
Okay, we don't have any disagreement with that.
No, I know, but I'm just telling her that that's the other section that we need to take. We need to excise that one line, was not engaged in unlawful activity.
Well, I mean, that's part of the standard instruction.
It is. If you're asking me to start changing standard instructions, I'm not going to do it. I understand, I understand your argument, but okay, so it's not harmful, and it's a standard, and I'm not messing with that. It's certainly not harmful, because there's been absolutely no indication that he was engaged in any unlawful activity.
Judge, I'll look for a case. I remember reading a case where...
But just, if for any second you think we're arguing that, we're not arguing that. There's no facts to that.
Yeah.
Right,
We're not.
right.
I mean, I really feel like
But
we're
it's
arguing over
the
nothing.
language, it's in there. I didn't write it. I didn't write the bit about the plea of not guilty that keeps referencing conviction. But that's what we've got.
If you read the entire justifiable use of deadly force, it goes in there on various aspects where they want the court to actually draft a part of the jury instructions that's applicable to that case. I will try to find you a case, I believe reading a case where the parties actually agreed that that section was not applicable, and they took it out. And so
I'm sorry, that's a whole section. This is taking out like four
Exactly.
words in a sentence, and we're not going to agree to that.
No, I think it was the unlawful activity language that was taken out, but I'll find that case and I'll bring it to the court.
I don't really, my only thing is I'm not changing standard instructions. Unless it calls for it unless there's consideration for that. And it's one of the things that I'm supposed to change, or supposed to comport with the evidence. But I'm not just going to go around and decide, I don't like that language in that sentence, even though it's not an optional one, I'm going to take that out. Not going to do it, So, and I think most judges will be unwavering on that as well, unless we just are fans of getting reversed. So, oh my gosh, we've all seen hundreds of cases where, inexplicably, the trial court allowed a non-standard jury instruction, No, not going to go there unless I've got extreme guidance to let me do that, but I'll tell you right up front, that's not likely.
Yes, Your Honor.
All right.
I think that does it for the defense.
Okay. Was there something else that you were here for?
I think it was just
Just
the,
this?
We resolved that.
yeah, I think we resolved everything.
Okay, all right, good, then. So, as we sit here right now, you guys are on top of everything. Do you, let's just picture Monday morning, you know, we're getting started. Any snags envisioned or any problems?
There's gonna be some logistic issues that, because of equipment being used and having certain things ready to go,
Okay.
that need to be accomplished through the cooperation, and we've always had it, I'm not saying it won't happen.
Right.
Through the cooperation of the court system, the bailiffs, we accommodating and making sure all our equipment works, it's functional, all the batteries are new, you know, that kind of thing. So that'll try to be accomplished today, over the weekend, and then that equipment will be in the courtroom. The only issue, and I've discussed this with the bailiff, with our large screen, this is just logistically, it'll be set up so that one cord will be removed, it'll be unplugged, there'll be probably about 30 seconds of powering down because it's a computer, so I can unplug it. Then it will be wheeled through this area. If Mr. Reeves is sitting on the end, it might be necessary for that chair just to be moved over, and then it'll be pushed up against that wall face first.
It'll fit over there?
Yes, ma'am, I believe it will, and we're going to test that. And then it'll be simply the time to wheel it back, plug in a cable, plug it in the box, wait for the computer to boot up. So we're going to play with all that so we can tell you how that works and make sure our equipment is working. As far as the exhibits, I will hopefully have an exhibit list for the clerk and the court, defense over the weekend.
Okay.
So that that will be done. All the state's evidence is marked
Good.
and was marked with the assistance of Madam Clerk Tammy, told me how she wanted it done. And I've comported with that. All the other markings have been removed,
Okay.
and all her barcodes have been covered up.
Good.
And so that the new red label is on and ready to go. So that's all done. We have poster boards and photos, so we'll have video, poster boards with easels, photos on the Elmo. We'll be kicking that around for those days. So I think, you know, witnesses are available. Working out just some minor issues with Mr. Escobar. If they can be resolved, great. If they can't, it's not going to delay a thing. The
Okay.
state is moving forward. Even if I have to draw pictures with a crayon on a piece of paper and hold it up,
There you go.
it's going to go forward. You know, it's keep it simple, stupid.
Yeah, there you go.
So that's what's going to happen. So we're kind of ready to go.
You know, probably everyone in your office upstairs will be able to attest at one point or another. They have gone through all those steps with the Elmo and the computers, and they know just how they're gonna play this video, and it worked perfectly at 7:30 a.m. and 9:30 a.m. they come to play it, and nothing.
Yeah, I know.
Dead.
We've mocked up our courtroom upstairs using mock
Okay.
equipment. We've bought certain devices to make sure it works.
Yeah.
And that's what we'll do this afternoon, make sure it works, and then we'll test it out again Monday morning.
Yeah.
So
I'm
I
sure
know
it'll be fine.
at
Yeah.
7:30, we're not starting Monday till 9. We
Right.
can get in here at 7:30 with the
Yes, you
bailiff
can.
and make sure everything's working. So we've taken whatever steps we can,
All
and
you
as you
need.
know, when you're dealing with electronic equipment, it happens.
Yes, it does,
And
and
then-
I'm pretty sure we have IT in the building next week, every day of the trial,
Yeah,
so.
Teresa's, she'll be here.
Yeah,
And Aaron Smith will assist me with the mechanical stuff.
okay,
He knows how to do all that.
Yeah.
He's listed witness, but
I
he's
know.
not here.
Judge, I just remember there's one thing that I don't think is going to be an issue, but we ought to probably bring it up. Last week, I received from the state a list or new discovery, that listed individuals that were not previously listed as experts. And so
Okay.
obviously, myself and Mr. Martin had a conversation, because that was a big issue. Now I've got, 5 new witnesses here that he's saying now are experts when I've deposed them as non-experts.
Okay,
And so that was gonna be.
We'll discuss that, Judge.
okay,
And so what we did is that, when we discussed it, he said, no, they're not experts, they're fact witnesses. Just want to make sure
okay.
that they are going to be fact witnesses. I don't have that list here in front of me, but.
I don't have it either, but Mr. Escobar and I will work that out. It's not going to be an issue.
Okay.
All right, I mean, we all know the rules on that, so it is what it is. We'll get to it and do it.
We're going to handle it.
All right.
Judge, I'm just gonna chime in. After the state's opening, we're gonna need some time to set up as well.
Okay,
So there'll be, a slight lag between. It won't be, okay, the fence ready.
okay. But
Give your
typically, that's a
opening.
good time for a
All
recess
right.
anyways.
That's good. I just didn't want to have to ask you.
I mean,
for it.
unless his opening is like 10 minutes, but I don't anticipate that. It's Mr. Rosenwasser,
Yes.
isn't it? Yeah. You're gonna, 45 minutes to an hour?
Yeah, an hour tops.
Okay, it's not gonna be 10 minutes.
No.
Okay, because that would be a little odd if we, just start and take a break. But it doesn't matter. I mean, if it's odd, it's odd. So, but I would anticipate probably at least 30 minutes.
Okay.
And
Maybe
that-
about an hour.
Yeah, that'll be fine. So that'll be a perfect time for a break. And we'll give a little longer one if it's gonna take,
It
15
may,
minutes.
so that's the only reason I bring it up.
Okay, that'd be
And
fine.
what concerns me a little bit is anytime, we're going to set up, are we showing evidence that's not in evidence yet? So I think we need to have some colloquy about if certain things are going to be shown to the jury. The state, I believe, has the right to know what that is, so make a determination whether or not there's any objections, whether it needs court approval.
Okay,
So that
certainly.
needs to be done.
If there's any evidence that's gonna be shown, it certainly ought to be discussed before it's shown in case it's not admitted.
You will, and we'll get with Mr. Martin on that. Off the top of my head, things that we plan on showing the jury in opening will be things that have been stipulated to or have been previously admitted, or things that the state's going to admit, so I don't,
Well, that doesn't tell me anything.
Well, okay,
Okay.
the video of what happened.
So you're gonna find
Videos
the
that they've
video.
been stipulated to, parts of it.
Okay. Now, are you gonna call it a fair and accurate depiction?
Judge, I'm just gonna show the video, and so anyway, we'll go with Mr.
Yeah, we're gonna have some issues if we're playing this Lego video to the jury, so
No, I didn't.
that's good. Here's the other thing. I've discussed this with Mr. Escobar. He says that his expert is doing certain things to make certain things work the way they play it. I haven't been provided any of that. I haven't had a chance to view anything from their expert that's new. I've been told I'll get it over this weekend. I haven't had my expert time to look at it. So I know we're at the eve of trial, but as Mr. Escobar pointed out himself, the interpolation issue he brought up 6-7 years ago. So why are we now at the eve of trial with his expert now redoing certain things that I haven't seen 2 days before we start? So I'm trying as fast as I can to get that information from Mr. Escobar so we have a chance to review it, so we have a chance to look at it. And I know Judge Lewis's order came out, and quite possibly, it's a response to Judge Lewis's order, and that only came out recently, I understand that. So I'm a little concerned about those type of things being played in opening, but I haven't even seen them yet.
Judge, if I may, he knows what we're doing because my expert used nearest neighbor to resize the video. I mean, it's no different. The only thing he's doing now is that he's resizing it to a 75-inch screen using the same formula.
Okay, we don't need to get
Yeah.
into all that, but procedurally, is this what you're gonna request to be admitted into evidence?
Oh, yeah.
And is it the same that's been used all this time?
It is the same resizing formula that has been used by my expert from the very beginning.
And
All
you're
it's
talking
doing,
Mr. Koenig?
Mr. Koenig, all he's doing is, for example, if we had resized it for a computer screen, or we resized it for a 32-inch TV, and now it's being resized, we're just adding the same pixels in that video to enlarge it.
And I haven't stipulated to that, just like he hasn't stipulated
I
to
don't
my
need to.
stipulation.
I'm going to present Koenig, and he's going to lay the predicate.
So our
Well-
position would be he can't play it in opening because we're not stipulating to it. He's got to lay the predicate in order to see if it comes
Before
in.
it can come in, yeah, so,
Well, then they shouldn't be allowed to do it either.
well,
You're-
that's
you
why I
haven't
asked
stipulated.
about how's the video gonna get shown the first time? And, you know, is there gonna be some agreement, some introduction, that everybody agrees to, so.
We'll talk about what our list is and.
Yeah, I mean, I don't care, and I'm glad you brought that up, Mr. Michaels, because it just, these are the sort of things that I want to know, so we don't have, you know, have this discussion Monday morning. So, go through anything that you intend to do in openings with each other, and either stipulate or we'll talk about it.
Well, that video, I think we agree, the one that you're talking about, the resizing one we haven't seen yet, we would object to that being played in opening.
Okay. So let's.
We'll be in communication. I mean, there are obviously ways around it. We've stipulated to a whole bunch of stuff.
Maybe we'll see it, we'll think
that we can.
Right.
That's fine.
Right.
Yeah.
You know, I intend to be here pretty early Monday, before 9 o'clock, so, if we need to, we can talk about it.
Judge, and so I heard that the doors were going to open at 7:30 because,
On Monday, yes.
Just not every day.
Oh, not every day.
probably. That's not a given, 7:30 is usually when jurors are coming.
I got you.
On Monday.
But,
However, there are new jurors coming in on Tuesday and Wednesday
Okay.
for public,
okay,
and we're going to get our jurors and go ahead and bring them straight to the deliberation room, so they're not in there
in there with them.
with the new jurors coming in for public.
Okay.
That's what Ron was talking about today.
Okay, all right. Well, that
Check them
should
in
be
and bring them
fine.
on over into that deliberation.
What, for like, well, they're not coming until later.
Yeah,
They're not
they're
coming
coming
at
till
7 o'clock,
Yeah,
right,
yeah.
so, okay, yeah, that'll be fine. Yeah, that's a good plan. Okay. All right, so you do have a couple little things you need to talk about this weekend, and,
Hopefully today,
yeah.
while Your Honor's still here, and we can.
Well, let's talk about that. Can we go off the record, please? So, that's all, and it's not, you guys are doing fine. Don't sweat the small stuff, it'll be okay. You're all very experienced, it's going fine. So, all right. So are we good for now? Do you have any orders that I can sign right this minute?
I
That's fine.
But, I
Well-
know what they are.
Okay.
Get to them for their approval.
Okay,
It's just gonna say granted, just like.
right, right.
granted, denied.
It's simple, yeah.
You can check it and sign it. And
Okay, I'll make sure, as long as I check the right one. If you guys agree on what I'm supposed to check, go ahead and check it, and I'll sign it.
That's probably a good idea.
Yes, it's not a bad idea at all, so,
Okay, well, yeah, we'll work that out, so it'll be very administrative
okay.
when we see you again.
All right, so the first order of business Monday morning will be swearing the jurors, and then the little preliminary instructions, probably 4 pages of that, and then go into openings, and we're off. So, well done, everybody.
Thank you.
We'll see you Monday morning. Let me give you guys, I don't have a card up here, but I'll grab a card and give you my cell if you want somebody walk over by my office. So, all righty. Huh? Yeah, I think I've got your cell on my desk. Oh,